Returning to my Coin Lady channel, I am pleased to see you again. The judge who offered Ripple and XRP hope was Analisa Torres. A federal court and cryptocurrency sector supporter, Analisa Torres, granted Ripple some victory in its fight against the U.S. Securities and Exchange Commission in July of last year, boosting the cryptocurrency industry overall. For the industry judge, this win marked a major advancement. Although Torres found that Ripple had broken federal securities laws by selling XRP to institutional clients instead of normal users through exchanges, he nonetheless included this profile among the most significant. The CoinDesk in 2023. There is a lack of legislation from Congress that could provide clear guidelines, protect token issuers and trading platforms, or clarify how federal securities regulations should apply to digital assets. As a result, the cryptocurrency sector and the Securities and Exchange Commission are unable to reach an agreement on this matter. Businesses argue that the laws that are currently in place are incorrect and out of date. The United States judicial system must decide whether the Securities and Exchange Commission's explanation is correct or not. Advertisements at issue is more than simply a scholar. The United States has strict disclosure and registration requirements for asset issuers whose assets are classified as securities. Digital asset issuers, according to cryptocurrency businesses, cannot comply with these regulations. As with their traditional financial counterparts, trading platforms that feature decentralized and disintermediated tokens are subject to a strict regulatory environment. This is because of the asset's very nature. Everything is also much easier for these companies if an asset is not deemed a security. This topic is particularly important in the District Court for the Southern District of New York because it is overseeing about a dozen crypto actions, including multiple claims filed by the Securities and Exchange Commission. Reason being, Judge Torres found that Ripple sold XRP to retail investors illegally and might do so again through exchange blind bid hacks. The jury's decision may set a standard that the business world can use again and again. It is impossible for programmatic purchasers to tell whether their funds went to Ripple or any other XRP vendor. The vast majority of people who purchased XRP from digital asset exchanges did not make any investments in Ripple, as the judge pointed out in his ruling. Regardless, a large buyer purchased XRP from Ripple in a legally binding contract. Statistically speaking, a programmatic buyer's situation was identical to that of a secondary market buyer in that neither knew to whom nor what it was paying. As an example, consider how the decision sent shockwaves across the company. However, questions about the precedent etc. arose as a result. Exchanges, and an attorney whose clients are active in the cryptocurrency industry, reaped significant benefits from the ruling. The decision's potential positive impact on Bitcoin firms and projects, however, is highly subjective. Only one courtroom within one courthouse is now hearing the verdict. When the dust settles from this case, the Securities and Exchange Commission will undoubtedly file an appeal. In what seems like an attempt to speed up the appeals procedure, allegations against Chris Larsen and Brad Garlin, two executives of Ripple, have already been dismissed by the regulatory authority. The decision could open the door for initiatives to solicit funding, as previously described to reporters, if the Court of Appeals upholds it. Judge Jed Rakoff, who presided over the SEC's action against Terraform Labs, also rejected Judge Torres's rationale. Therefore, Judge Torres's conclusion could be an outlier in his own summary judgment opinion. It may take some time for the Court of Appeals to make a decision, though, because the specifics of that rule were obviously unique to that instance, just as the specifics of the Ripple ruling were unique to this case. No appeal can be filed by the Securities and Exchange Commission until the matter is settled. Because additional procedures have been scheduled by Judge Torres and will go until April 2024. The long-running legal struggle between Ripple's and the Securities and Exchange Commission has taken a surprising turn, according to CEO Brad Garlin. He hinted to a potential confrontation, which sparked speculation about a possible settlement or major outcome. Legal professionals specializing in Bitcoin swiftly reacted to this tweet. According to crypto law expert Bill Morgan, the excitement is all just rubbish. A settlement meeting, in his view, signifies the end of the legal battle. An epic showdown is not the same as a settlement, he says, taking his time to make that point clear. It necessitates giving something up. There will be chances for settlement and challenges to overcome, as well as an agreement on certain issues, between the two sides. Settlement talks are unlikely, according to Morgan. He raises the valid point that settlements are the usual means of resolving disputes, yet, this approach sometimes involves appealing the decision, which raises serious concerns. Furthermore, the settlement's true effects may be far-reaching beyond what is currently being considered. Rumor has it that part of the money resting in that infrastructure might affect the XRP sales after December 2020, and any sales that follow. Thank you for watching my channel and for subscribing. I'll see you later.